do so in terms of a duly passed resolution attached to the main application. May it please the court.
I affirm my appearance on behalf of the third applicant, the Rally for Democracy and Progress, as the resolution attached to the application.
As I got this, Your Lordship, Mr. Nekwa and I appear on behalf of the first respondent, second respondent, the 14th respondent, and the 16th respondent on the instructions of the government attorney. As I got this.
Thank you, Mr.
Your Lordship, you might have had an opportunity. We tried our best to file papers right after 8, and I hope that such papers have reached your chambers.
All I received was the notice of opposition, Mr. Namanje. I received that at about 8:30.
Because we did file a notice of opposition together with the answering papers at the same time, and
all I have, as I indicated to you, is the notice of opposition.
and we actually have proof that at the same time when the notice of opposition was filed.
Well, then it's a matter between you and the registrar.
Because Mr. Shikwambi in particular was urged to make sure that the two pleadings are taken to the judge. In fact, there was a special copy that was made.
I'm sorry, Mr. Namanje, I see it was placed on my file, but it was probably placed on my file after the file had been removed from my chamber.
Your Lordship, there are a number of...
my Lord, that's my point of order. We are also hearing, I'm here, Gators, the leader of the workers' and for something. I'm here appearing on behalf of the 13th respondent.
The 13th, the Economic Freedom Fighters. That is the 18th respondent. That is the 18th respondent.
Your Lordship, what I was about to point out is the fact that in the papers, there are a number of procedural and objections, issues on locus standi and a number of points raised concerning what we consider to be fatal non-joinders, given the nature of a wide range of relief being sought by the applicant. I would propose, Your Lordship, that because those points, Your Lordship, are legal points and they are summarized, I will be able to take the court directly to the papers where they, in short and clear, raised, so that those issues, we have been invited in this court and we were informed that the application is today. We want to deal with an application, we worked overnight for it, and I propose that since we raised a number of objections, procedural objections, that such be dealt with first, and in that respect we have the right to begin, Your Lordship.
Yes. Have these papers been served on all the respondents?
Indeed so, my Lord. We have filed the various returns of service with this Honourable Court's Register this morning. I have copies thereof with myself, my Lord.
I have them,
Yeah.
but I see, for instance, the 11th respondent wasn't served.
Lord, our instructions to the messenger of court were quite clear that the document is served on all the respondents cited in this application.
Well, the 11th respondent has not been served. The 13th respondent has not been served. The 7th respondent has not been served. What do we do about that?
My Lord, if the respondents in question could not have been served because of them not having an office in Windhoek, not having an address where they could be contacted.
The offices were closed according to the terms of service. On what basis do you contend that you can still proceed with the application today?
My Lord, it is not unprocedural for documents to be served.
They weren't served. That is the long and the short of it, Mr. Maletsky.
My Lord, I acknowledge that non-service on some of the respondents, my Lord, is a serious defect.
Yes.
That is not attributable to the applicant. The seriousness of this application, my Lord, and the most relevant parties with a that has a direct and substantial interest in this matter, my Lord, are cited and are before this honorable court.
Well,
I should mention to you, my Lord, that some of these respondents were simply cited insofar as they may have an interest in this matter.
Well, you've chosen to cite them. If you've made them a party, they must be served, not served. If you've chosen to cite them as respondents and you do not serve your papers on them, then on what basis do you want to proceed?
My Lord, I wish to inform this honorable court that yes, we may proceed with this application, because if these respondents claim that they were prejudiced because they were not cited because of the fact that these papers were not properly served on them, they could take recourse to this honorable court. It's not that as if they are without relief.
They have the right to be heard.
And that right, my Lord, would be afforded them in terms of the rules of this court.
Yeah, one of which is that you must serve your papers on them.
My Lord, this honorable court would agree with us that the best mode of service is through the office of the messenger of the court, the deputy sheriff of this court. And if we approach the office of the deputy sheriff of this court with instructions that these papers be served, my Lord.
Well, he attempted to. See, I have a fundamental difficulty with that, Mr. Maletsky.
My Lord, but with respect, my Lord, the issues raised in this application are of such serious concern that non-service on some of these respondents who, with respect, my Lord, have a very, very minor interest in this matter, cannot bring about the dismissal or the striking from the role of this application. Not in light of the fact, my Lord, that the deputy sheriff of this honorable court was entrusted with that duty to cause service upon all the respondents.
You see, you told me that everybody was indeed served. Now I pointed out to you that it is not so.
My Lord, given the urgency of this matter and the fact that I have only obtained these documents confirming that these respondents were served this morning, I did not go through each and every one. So
Very
yes,
well.
indeed, my Lord, I'm caught off guard that to learn that some of these respondents were not served. It is quite evident from the documents before this court, my Lord, that the deputy sheriff of this court was tasked with the duty to serve these documents. And if, my Lord, the respondents' offices were closed at that hour, well, the respondents have the duty, in terms of the rules of this court, if they are prejudiced, my Lord, to approach this court any other time.
For all I know, they may not even know about it or what it's all about.
With respect, my Lord, I submit that the case made out by the applicants by far outweigh the interest of some of those respondents who are not before this honorable court today.
Well, some of them are political parties who take part in the election.
My Lord, if political parties have offices that are closed during the day, where should these documents be served?
Mr. Bekes, I'll give you an opportunity. Just let Mr. Maletsky finish.
So, my Lord, if political parties taking part in these elections close their offices at 4 o'clock in the afternoon, they run the risk of not being served.
Mr. Maletsky, the onus is upon you as the applicant to serve your papers on the respondents that you've cited.
My Lord, I appreciate this court's concerns, my Lord.
Yes.
The fact remains that if the return of service indicates that a political party's office was closed at a specific hour during the day, which normally is an office is supposed to be open, my Lord, in such circumstances, they forfeit their right to be served. If the offices are closed during what is supposed to be office hours, then they forfeit their right to be served.
Where is your authority for that?
My Lord, logic dictates that. If you have a political office, or if you are running a heuristic entity, my Lord, and you have an office, this office should be accessible to members of the public. Public policy dictates, my Lord, that you cannot have an office with closed doors during office hours. The very purpose, my Lord, why a political office should have an office that is manned by staff from 8 till 5 o'clock in the afternoon is for it to be accessible to members of the public. With respect, my Lord, and if they were closed at that specific hour, my Lord, it forfeits their right to be served with this. They forfeited their right to be served with these papers. May it please the court, my Lord.
Mr. Beekes, you wanted to say something?
My Lord, the circumstances of the service of these papers are as follows. The Deputy Sheriff was given the papers yesterday, fully knowing that it was an urgent matter. I happened to be with Mr. Maletsky this morning when he frantically collected return of services from the Deputy Sheriff. And that happened about 20 to 9. So I was under the impression that all the parties were indeed served.
Well, as I've indicated to you, that impression is erroneous.
I would request this honourable court to postpone this matter to, or to adjourn this matter to 1400 for us to be able to serve the matter, the papers. If we tried unsuccessfully yesterday to collect the return of services now, had we been available of the return of services yesterday, we would definitely have picked up that these parties were not served. Thank you.
Any of the other applicants wish to say anything? Madam? Just please stand up when you address me.
We propose that the case be postponed to
We propose that it should be postponed to 1400 hours.
Mr. Namanje?
Your Lordship, what we were going to propose to Your Lordship, we thought at the time, having knowledge that, like our clients, particularly the first, the second respondents, they were also not served by yesterday evening. They were not served. But what we were going to propose, given the procedural points that we have taken, in fact, even on the merit, and in view of the fact that the election is taking place on Thursday,
Yes.
it is so important for our clients to have this matter dealt with, so that the uncertainty as far as preparation is concerned is addressed through some kind of a ruling by this court. We worked overnight, Your Lordship, because the applicants choose to come to this court in the fashion they choose. And if there were applicants or respondents that were not served with court papers, the authority, Your Lordship, of Node versus Nico Josia, a judgment of Justice Damasen, is that, particularly in view of the urgent matter and the special nature of this matter, that will mean that the application is a nullity. There was no proper service to the party that are necessary to the proceedings on that basis on authority. And we are prepared, Your Lordship, to address the court on the, as they contend that they want to be heard in the circumstances. Your Lordship, you can give them a hearing they are asking for.
No, but Mr. Namanje, unless you can give me some authority for what you say, that I can proceed to hear a matter in the absence of some of the respondents who had not been served.
I'm not contending, Your Lordship, that there is an authority that the court is entitled to proceed. without hearing the necessary parties to the proceeding. But what we are saying is that if an applicant, a litigant comes to court without the first material step in litigation having been properly complied with, then that will mean that the papers before you are a nullity on the authority I referred to, yes, Your Lordship. And what we are saying that the matter is so special that all our clients, Your Lordship, because of the preparation for the election and the uncertainty, we would want this matter to be addressed today on the papers filed by the applicants, Your Lordship. Your Lordship, we are of the view that the points we have taken in any way are of the nature that this matter could be disposed on the basis of the points we have taken, particularly on issues relating to non-joinder of a number of parties, because even if, Your Lordship, you will see the nature of the points we have taken, even if you give them an opportunity, this court will still be in a situation where it will be in a dilemma whether, with regard to the non-joinder point we have taken, whether the matter in view of the looming date for the election should be postponed to give them an opportunity to join the necessary parties that have not been cited, or the court should use its discretion to dismiss the matter simply on the point of non-joinder, Your Lordship. So it is so critical, in fact, understandable that our clients are of the opinion that, and plead with the Honorable Court that we get some kind of a hearing today so that at least the uncertainty, particularly with regard to the first respondents' preparations and the information going out to the voters, whether or not there is an election, this matter should be addressed and heard today. They choose to come to court in that fashion, and I submit, Your Lordship, we can convince you with reference to case law that the effect will be that these papers are so bad to the extent that they are a nullity and the matter can be disposed on that basis, Your Lordship.
Well, even if I were to be with you, then where does that take you as far as your complaint is concerned that it will hamper your preparations? You won't have certainty on your preparations. If you say that the papers are a nullity, for instance, because some parties have not been joined, well, then we don't get to the merits, do we?
We don't get to the merit, Your Lordship, but at least there will be a disposal of the matter. Your judgment, Your Lordship, in that respect will be final in effect. Then they will take procedural steps to assert their right at an apparent level, if they so will. But we cannot be held hostage, Your Lordship, because a careless litigant comes to court in the fashion they choose. They gave us papers, they have the papers saved on us. Yesterday, on one of our clients, yesterday after hours, made us to work overnight, comes to court with their papers in shambles. Now they're asking for time. It's just unfair, Your Lordship, not only to our clients but to the nation. So, Your Lordship, in the event of the court not being inclined to hear the matter now, I would propose that perhaps the matter can be moved to 11 o'clock or so, to give them 2 hours or so to put their house in order. Those are our arguments, Your Lordship. We feel that the matter must be heard. Alternatively, Your Lordship, the applicants could be given, if at all, a period of about 2 hours. We have set out the prejudice in our papers as to why this matter need to be dealt with, Your Lordship. As the court pleases.
Anything you wish to add, Mr. Maletsky?
May it please the court, my lord. My lord, with respect to the submissions made on behalf of some of the respondents, my lord, if this court is so inclined to grant us time to service, to properly serve these documents on some of these respondents, my lord, I submit that would be the proper course, because there is no guarantee, my lord, that should this honorable court dismiss this application on the grounds of non-service on some of the respondents, that the applicants may simply get their house in order and then approach this court on the very same purpose again a day or a few hours before the election. So it is therefore very important, my lord, that this case indeed be heard today. May it please you, this court, my lord.
My lord, on behalf of Namibia Economic Freedom Fighter, we found the importance of this application from the applicant himself as a national interest. And I find it very important that if a case is of agency, it does not say whether the respondent has ample time to prepare himself or be served in proper time. But I can see as our party is respondent number 80, we are here in the interest of justice. And on behalf of Namibian Economic Freedom Fighter, we say, let the applicant get a fair trial and fair opportunity to air his grievances or their grievances. So we do not have any objection for 1400 hours.
No, I'm not giving you until 1400 hours. I will resume at 11:30.
As the court pleases.
As the next recording word, Gentleman bidding my so as a
Of thousands of Namibian voters spread all across the regions of this country. The consequences of denying these multitudes of people their fundamental human right to vote for candidates and political parties of their choice in a transparent, credible, free and fair election has dire consequences for our country. The respondents, as national leaders, have taken oaths to uphold the law and in particular the Constitution of Namibia. And failure to do so will result in irreparable harm to the electorate which cannot be redressed in any other manner. I respectfully submit that in the circumstances the balance of convenience favors the applicants that this application be heard on an urgent basis, as there is no alternative remedy available to the applicants. I respectfully draw this Honourable Court's attention to the fact that both the Namibian Constitution 3rd Amendment Act of 2014 and the Electoral Act 5 of 2014 were signed by the President on the 19th of September 2014, which raises the additional question of why these two laws went through Parliament with such great haste and concurrently so. The respondents must answer these questions. My Lord, I assert that in a society characterized by scandalous poverty of the minority and abundant wealth of the majority segment thereof, it is a scandal to bring about constitutional alterations to the country's highest law without proper public participation, and to do so a few months before the presidential and National Assembly elections. What is more disconcerting is that such changes affect the entrenched provisions of the fundamental rights in the Namibian Constitution. My Lord, this application involves constitutional powers and rights. It involves Parliament's constitutional functions and duties, and it involves the Namibian people's rights to participate in the amendment of their supreme law. Article 5, 17 and 25 of our Constitution is cognizant of our past dehumanizing history and apartheid draconian laws, and amongst others seek to do away with such evil by involving the people in the democratic processes needed for the consolidation of democracy. My Lord, Article 1 further provides that the people of Namibia own this state of Namibia and that they shall exercise their powers through democratic institutions of Namibia. The Electoral Commission of Namibia is one of such institutions, my lord. And writing to the Electoral Commission of Namibia to air concerns and to alert them to the threat of multi-party democracy is one of the avenues open to the applicants in terms of the laws of. My lord, a comparative analysis of the purpose of section 97, subsection 3 and 4 thereof, which was to guarantee a transparent, credible and free and fair elections, and the purpose of section 209, subsection 2 of the Electoral Act, jointly conceded with the government notice 208 of 2014, which effectively suspend the operations of section 97, sub 3 and 4 of the Electoral Act, renders section 209, subsection 2 of the Electoral Act and its offspring, the government notice 208 of 2014, unconstitutional. And that all actions done thereunder are of no consequence and nullity in law. My lord, in conclusion, my lord, there is separation of powers between the executive, the legislature, and the judiciary in Namibia. There's only one constitution and one parliament in Namibia. The constitution provides that parliament makes laws and that these laws must promote the constitution. To allow a member of the executive to implement laws selectively with the intention to defeat this constitutional imperative is to disregard the highest law of Namibia, of which this honorable court is the upper guardian. A minister suspending section 97 sub 3 and 4 under the guise of another provision of the Act, that is section 209, subsection 2 thereof, failed to act in the best interest of democracy and the Constitution of Namibia. My lord, we respectfully submit that this court is the upper guardian of the Constitution of Namibia and is obliged to ensure compliance with the Constitution in every case placed before it, and must do so herein by granting the relief set out in the notice of motion. My lord, while we accept that the principle of separation of powers is not rigid, we cannot conceive of a more coherent account of the principle which would permit a member of the executive, my lord, to at will dispense with a statutory provision which Parliament meant to maintain transparency, accountability, and democracy in this country. To exercise such powers without any apparent consideration of the Constitution, my lord, is a flagrant violation of the Constitution itself. It is equally unheard of, my lord, that the first respondent opts to use electronic voting machines without the paper trail because the remaining sections of the Electoral Act 5 of 2014 empowers it to do so. No reason is provided, my lord, to follow the provisions of an act blindly without considering the constitutional consequences for this country, my lord, is an error on the part of the Electoral Commission of Namibia. Every law in its purpose should be considered in line with the spirit, purport, and object of the Constitution of this country. We submit, my lord, that in this case, no statutory provision, however prescriptive as section 209 sub 2 of Act 5 of 2014, would be sufficient to render constitutional the consequences of doing away with the means to verify an election outcome. My lord, there is just no way that this court could come to the conclusion that the purpose of section 209 subsection 2 of the Electoral Act 5 of 2014 should be interpreted to do away with the means to verify an election outcome and to send the Namibian nation to the polling station to cast their votes, knowing very well that in the event of a dispute, their election results would not be verified. For all these reasons, my Lord, we submit that the suspension of Section 97, 3 and 4, in terms of Section 209 of Act 5 of 2014, is inconsistent with the Constitution of Namibia, and resultantly, my Lord, we pray for the relief set out in the application. My Lord, in conclusion, my Lord, I just wish to draw this Honourable Court's attention to remarks by the Honourable Judge Maritz in the Supreme Court of Namibia, case number SCR 3/2007. It's in the matter between Hendrik Christian, the applicant, versus Metropolitan Life Namibia Retirement Annuity Fund as the first respondent and others, my Lord. My Lord, in that judgment, on page 10 thereof, page 9 and 10, the judge indicates, the Honourable Mr. Justice Maritz indicates that the interest of justice and fairness demand that courts should consider the substance of their pleadings and submissions rather than the form in which they have been presented. The applicant might have articulated his grievances inaptly, might have overreached the ambits of his rights, might have adopted the incorrect procedure, but the substance of his complaint, which this court had to take note of, remained the same. That is, that the order made against him was vitiated by irregularities in the application proceedings before the High Court. My Lord, I just mentioned that for this Honourable Court to take note, that the substance of this application should take precedence over the form in which it is presented and the fact that it is
familiar
brought.
with the decision, Mr. Manes.
May it please the Court, my Lord. Those are my submissions.
Do any of the other applicants wish to address me? Mr. Bierkes?
Yeah. My Lord, I concur with what Mr. Maletsky so eloquently presented to the court. I just want to mention that this is an issue of universal franchise. I want just want to add. And universal franchise means universal. All may vote.
Perhaps just stand a bit closer to the microphone, Mr.
All may vote. And I submit that inherent in the concept of all may vote is that all may know that they may vote, that the vote will count. Now, in this particular instance, nobody in this court will even know whether their vote will mean anything. Now, this may be a snake that comes to bite all of us. And I refer the Honourable Court to George Orwell's 1984, in which people were told, I am your president and I congratulate you on your wise choice. This may be the situation. And this is all that we do not want future generations to be congratulated by the president who has appointed himself for their wise choice. Those absurdities are inherent in this machine. And I need to point out that Germany, which is a known democracy, the US of A, Britain, all these Western democracies, who are the highest democracies in the world, have banned the use of EVMs. And I think that must count for something. Namibia is one of the African countries who have, after more than 100 years of bloody struggle, have won the right to vote. And I think we need, for future generations, that we are not prescribed by some machine whose innards we do not know to make the decision for us. It militates against our sovereignty as a nation. It militates against our free choice as a nation. And we have to depend on some Indian in India who was the programmer to decide our future for us. Thank you, my Lord.
Thank you, Mr. Davis. Any other of the applicants wish to add anything? Lady?
I totally agree And I want to preserve democracy for my future grandchildren to be born and the generation to come after.
The gentleman from the economic freedom fighters. Yes. I'll give you an opportunity now.
We, as respondent on the application, would like to.
Just come and stand in front here, if you will, please.
We, the Namibian Economic Freedom Fighters, would like to ask the Honorable Court to award judgment in favor of the applicants in this case. We are not objecting anything.
Mr. Namanja?
As the court pleases, Your Lordship, first of all, before I make my submissions, may I just, Your Lordship, shortly set out as to what we, not we thought difficulties, understood as the applicant's case. It appears, Your Lordship, that the central issue relating to the Section 209 of the Electoral Act and the notice that in effect delayed the coming into operation of Section 97, subsection 3 and 4. We understood the applicant case in that respect as based on the ground that because of the concept of separation of power, it would have been wrong for the legislature to provide in the Act that the minister concerned has power to select certain sections to come into operations and some not to come into operation. As we understood the argument, then a minister as a member of the executive could never have such powers as, in the applicant's opinion, that would amount, that would be unconstitutional on the basis of separation of power. That is how we understood the case.
Yes.
Secondly, in respect of the amendment, the third amendment to the Namibian Constitution, as we understood the case, the applicants have problems with the amendment primarily because they say the democracy in Namibia, in their words, is participatory as well as representative. On that basis, they argue, as I understood my colleague, that if you have, in respect of ordinary statutes, not the Constitution, where in certain cases, members of the public are given an opportunity to comment through public hearing by certain committees, then constitutionally and democratically on their arguments, it should follow that you cannot amend the Constitution without employing a consultative process for the members of the public to have a say in the constitutional amendment. Let me start with the first issue, Your Lordship. The first issue pertaining to the minister and the provisions of the Act concerned. Firstly, unlike the South African Constitution, Your Lordship, the Namibian Constitution does not explicitly make provision for the public to be consulted and to participate
in the law-making process. In other words, in the legislative process. It does not. Section Article 17, 1, sub-article 1 of the Namibian Constitution, that appear to be the basis for the applicant's quotation, reads as follows, Lordship. All citizens shall have the right to participate in peaceful political activity intended to influence the composition and policies of government. I wish to highlight that political activities, a distinction between political activities in general and the legislative process. And I will refer to cases, Your Lordship, where it is clear. In other constitutions, where the founding fathers intended and meant that the public must participate directly in the lawmaking, they use the language of a legislative process. The article continues. It then says, all citizens shall have the right to form and join political parties, and subject to such qualification prescribed by law as are necessary in a democratic society to participate in the conduct of public affairs, not legislative process, whether directly or through chosen representatives. Your Lordship, even if you are not with me, that conduct of the public affair does not necessarily mean to be directly involved in the legislative process, even if you are not with me. The Constitution made provisions are optional. Either they could participate in the conduct of public affairs directly, in other words, probably being consulted and take part in that process directly, or through, and I highlight the word or through freely chosen representative, people like applicants' representative in Parliament. Those are the freely chosen representatives who can represent the applicant in the conduct of public affairs in the context of lawmaking. The South African Constitution, Your Lordship, is different from our own constitution in that context. In fact, it's a I wish to refer Your Lordship to a judgment of Merafong Demarcation Forum. This is the President of the Republic of South Africa. There are a number of separate judgments by the 11 judges of the South African Constitutional Court. The citation is 2008.
I've been provided with a copy. I've been provided with a copy.
Yes, Your Lordship. 2008, Volume 5, SA 171. Your Lordship, I wish to take you to page 237, particularly the judgment of Justice Madala. Paragraph 206. Quoting Justice Ngobo, in another matter, the Constitutional Court stated, our Constitution contemplates a democracy that is representative and that also contains elements of participatory democracy. As the preamble openly declares, What is contemplated is a democratic and open society in which government is based on the will of the people. Consistent with this constitutional order, Section 118, subsection 1, South African Constitution refers to sections, not articles, A, calls upon provincial legislature to facilitate public involvement in the legislative and other process. In other words, there is an explicit constitutional obligation on the legislature in South Africa to facilitate direct public involvement in the lawmaking process. That is not the scheme and the structure of our Constitution, Your Lordship, because if you go to Article 132 of our Constitution, Your Lordship, dealing with the repeal or amendment of the Constitution, it does not make any provision for a direct public participation in the amendment or repeal of the Constitution, save in cases like the amendment of the Bill of Rights, Your Lordship, as you know, where there will be a referendum and so forth. But Your Lordship, I'm not saying the legislature in Namibia cannot facilitate public participation in discussion of contemplated constitutional amendment.
You're saying that they're not obliged to?
Yes, they are not obliged. So that my colleague, the applicants, cannot assert a right by simply telling us that democracy in general requires such when we have explicit provisions of our own Constitution, Your Lordship, that do not accept of such a process. I therefore submit, Your Lordship, that the mere desire or the mere subjective, idealistic view of the applicant to achieve what they consider as highest standards of Germany and Britain, as per Mr. Biekers, does not translate in actionable constitutional right to demand public direct consultation in respect of...
I think Mr. Biekers makes another point. He says that other countries have abandoned the idea of electronic voting machines, but
first of all,
there's nothing on the paper. Yeah, there's nothing on the paper.
There's nothing on the paper. I understood him here to be a representative counsel like mine, not as a witness. But by the way, that is not the point, Your Lordship. All what I'm trying to say, first, the applicants cannot assert such a right in terms of our Constitution. Secondly, on the facts of this matter, Your Lordship, remember, Your Lordship, that the applicant choose the way this matter, the procedure, and the time period, how this matter should come to court. They served the respondent yesterday, and they did not ask for time to respond to the allegations of the respondent, even if, Your Lordship, in respect of the allegations being made by the applicant, they are bound by the procedural election they made. There is a matter, Your Lordship, is a judgment of S versus Mushena. It's a judgment written by Justice Damasen. It's 2004. I cannot remember the page, but I think it's 115, where the concept of an election, a party bound by an election, because they choose to have this matter being heard without them replying to the answering affidavit.
There are no replying affidavit.
Exactly. So that would then mean, to the extent there may be a factual dispute, the respondent's version, we thought any attempt to analyze evidence should be accepted. Having addressed that, I therefore submit that factually on this matter, the Attorney General, Dr. Kawan, attached an elaborate statement where allegations are made that, including the third applicant, of course headed by Mr. Hidipo, they were extensively consulted. Since Mr. Hidipo did not avail himself for a reply, the version of the respondent in that respect must be accepted. I move from this matter, Your Lordship, to the sections of the Act being impugned by the applicant. May I move on?
Yes.
Now, the applicants made several assumptions, legal assumptions that are with respect wrong. Firstly, they appear to have assumed that somewhere in our Constitution or at common law, there is a prohibition for an executive functionary to put a statute into operation. I wish to refer to a very relevant judgment on the issue, Your Lordship. It is a judgment of Pharmaceutical Manufacturers Association of South Africa. In ex parte, the President of South Africa. It's reported as 1999, Volume 4, SA. It is by no means unusual in this country and in other states that recognize the separation of power for the legislature to delegate to the appropriate functionary in the executive branch of government the power to determine the date upon which its enactment should take effect. Often, as in the present case, administrative preparations are required to be made as a prerequisite to bringing the legislation into effect. And it is best left to the executive branch of government to determine when the appropriate time has arrived. So it goes on, Your Lordship. So the point being made is, if for instance the EVMs, on the information that is available, it is not ready to be used with the paper trail. It is within the powers of the legislature to delegate the power to the minister concerned, who will then use his discretion, depending on the circumstances, to delay certain provisions of the Act until all preparation, administrative and technical preparations are put in place. So, Your Lordship, it is recognized in democratic countries, such as countries admired by the applicants, that the executive can do just like the Minister of Regional Government in this country did. Now, there is another problem with the applicant's case in that respect, Your Lordship, is this. They are attacking the notice itself on the basis of the fact that Section 209, which gives the minister the power, is unconstitutional. In other words, what they are saying, it was not open to the legislature to delegate to the executive the power of determining the coming into operation of certain sections of the Act.
Yes.
I submit that there are two fundamental problems in that. One of them, which is not a procedural matter, is a matter of justice and an opportunity to be heard. When you make such serious allegations against a certain branch of the state, represented, commonly referred to as the legislature or the parliament, you can't make such allegation on an important matter as to how they conduct their business, because we now know at least the Namibian parliament, in a number of statutes, as a practice since independence, they leave it to members of the executive to determine coming into operation of certain section and the statute itself. To come to this court and take a constitutional point to declare the section as unconstitutional, it will have far-reaching consequences and implications in future as to how the parliament conduct its business. Of course, we know now that that branch of the state is not represented in these proceedings. And that is not a procedural matter. First is a problem relating to justice and fairness and an opportunity to be heard. They can be heard in this court to attack on that procedural basis. And secondly, because of the judgment and other that I have referred to, in law, they are not correct, Your Lordship. I therefore submit that the 2 points that I have addressed have no merit whatsoever, and the court can reject them outrightly. May I address the few remaining issues, some of them factual, Your Lordship?
Yes.
We heard our colleague speaking so loud, Your Lordship, that
Wasn't that loud, Mr.
he was loud when he yelled that certain political parties, my clients in particular, the first respondent, have been guilty, and he suggests there appear to be a basis for fear that these elections again may be bound to be rigged amongst other parties by the first respondent. As a point of law, Your Lordship, in the judgment of the Director of Public Prosecution versus Zuma, it's reported as 2009, Your Lordship,
Yes.
Volume 2, page 170. Justice Harams states that when you make serious allegation like fraud against parties, then the requirement in law is that, unlike in other allegations, you got to have good evidence. You have seen, Your Lordship, that my colleagues for their applicants rely on secondary and conclusive allegations and does not allege in the papers any primary factual allegations upon which such secondary allegations are based, Your
Well,
Lordship.
it's more sort of a conclusion that they plead.
They,
More a conclusion or than a factual allegation.
yes. Yes, that there were direct and pertinent allegations imputing fraud to at least 2 parties, including the first respondent. But I'm saying, Your Lordship, that was made with an intention to dirty the atmosphere so that Your Lordship is convinced that we thought the paper trail, given the history of fraud and rigging of elections by no other person or parties, but by the first respondent who is statutorily charged with managing, conducting, and controlling the elections. So that if you were to accept those allegations, Your Lordship, then you would have a factual and reasonable grounds for believing, for having a reasonable fear that the EVMs we thought a paper trail may be a cause for preference for our elections. That is the only reason. So I therefore, as a point of law, Your Lordship, shoot down the allegation that they do not begin to stand up so that, Your Lordship, anybody would have feared that there will be fraud by those who were unfairly alleged to be fraudsters. Secondly, Your Lordship, another matter, the respondents filed an affidavit of an expert pertaining to the EVMs.
Yes.
It is tried, Your Lordship, that in proceedings, unless, of course, the court is not convinced that the person is an expert, but once it is uncontested that the person is an expert who can assist the court in deciding a certain issue, such as the capacity, capability, and the safety nature of the EVM, once it is not contested that that person, it's not disputed by the applicants, that that person is an expert, then it would follow that the evidence standard should be accepted. We, of course, as we said, they choose not to reply. The fact then remains that the EVMs are exceptionally safe, that in Namibia, come the 28th of November 2014, if you are with us, Your Lordship, the election will still be free and fair. Unless, of course, Your Lordship, there are any other reason apart from being the EVMs we thought paper trail. The remaining issue, Your Lordship, that I need to shortly address is even if Your Lordship were to be somehow convinced that there is a cause for concern.
Well, I don't know yet.
Yeah, but what I'm trying to say, Your Lordship, even if you were to be convinced on the fact, if you are not with us, the applicants still had a difficult duty in terms of the evidence that they must bring before you and must put up good facts and compelling circumstances so that they convince you that these allegations make out a case where an election process should be derailed. There is a case, Your Lordship, is the Republican Party of Namibia versus the ECN, 2009-10-1, at page 73, paragraph 103. Quoting from another judgment, the full bench of this court stated, when, however, the election is sought to be set aside, the interest is as much that of the constituency as that of the parties to the election. If an election is set aside, the whole electorate is affected, business is dislocated, expenses are incurred by the electors in going to the poll, the business of hotels and public houses is interfered with. Now, Your Lordship, just have this. The applicant admitted, it is clear from their own papers, that as far back as September, even as early as August, even in some instances during consultation, they were unhappy with at least two aspects of the process. Firstly, they admit they have never been happy with the contemplated amendment of the Constitution then. In respect of the EVM, they have been, at least some of them, have been threatening to come to this court as.
But Mr. Namanje, that all goes to the issue of urgency, which you decided not.
Not Your Lordship, but it's another angle, which is
Well,
at this late stage.
Let me hear what it is.
Yes, Your Lordship. At this late stage, it's not urgency, Your Lordship. It's a consideration when you weigh up on the basis of the principle I just stated. When you have 1 day, almost 1 day to go, after the process that starts with the registration of voters and many other processes, including printing of ballot papers, sending machines in the regions, bringing in international observers. A day before election, you have an applicant asking the whole process to be postponed. Your Lordship, I am submitting that even if at least there are some reasons to have a concern, this is a case on the basis of the principle Your Lordship has stated, that in your discretion, you can dismiss that application, Your Lordship. There are, of course, many other cases, Your Lordship. In the conclusion, Your Lordship, and I will only address those procedural, not because I want the court to strike the matter from the road. It's just in weighing up consideration, Your Lordship. There is particularly one of them that is important, which can have an effect on the merit. Your Lordship, if you go to section 63 of the Act,
The Electoral Act.
63, it is clear, Your Lordship, that when you speak in Namibia of the election of members of the National Assembly and the election of the President, although these elections are held traditionally as a custom, simultaneously, in law they are distinct, separate elections. Now, as I understand the applicant, Your Lordship, they want the whole process, as I understood, without even attacking and impugning in any way, Your Lordship, the proclamation by the President. Remember, Your Lordship, the President, there is a proclamation that set the date of election. That proclamation is not impugned in any way. But what they are asking you to do, as I understood, is to say the election on the 28th is not taking place. It must take place somewhere in February.
But I doubt that I've got the power to direct the President when to hold an election.
But Your Lordship, what I'm saying is this. The dilemma, technical and substantive dilemma you have been placed in is this. Assuming on the fact they made out the case, where are the candidates for the presidential election? Because that's separate and distinct elections. When they come to this court to attack the whole processes, the candidates for the presidential elections should be parties.
Are you now on the non-joinder issue?
Yes, it's a non-joinder, but it's the one that when you look at the remedy, because when you look at the remedy, it will be difficult, Your Lordship, to do anything. In other words, I'm not saying they must be joined, because the election is in 1 day, is 1 day ahead.
Shouldn't they have been joined?
They should have been joined, that's what I'm saying, Your Lordship.
Yes,
But this is a case, because of the nature of the application, this is a case, together with the merit, they are comparing reasons for you to dismiss the application, Your Lordship. Because an election should be postponed, necessary party to another election that is being postponed are not parties to this application, Your Lordship. May I just take instructions?
Yes.
Yes, Your Lordship, I was just reminded by my colleague that the whole process as to how the EVM works and the confidence building measures in the machine itself have been sufficiently stated in our affidavit, elaborate affidavit by the expert. And we were so kind, Your Lordship, to attach all the necessary explanatory information, including the manual on our answering affidavit, Your Lordship, without wasting time. For purposes of the court deciding and the interest of time, I the affidavit, Your Lordship,
Yes.
after the affidavit of the...
It's Mr. Rao's affidavit.
Yes, Your Lordship. It's a very useful And I wish this affidavit somehow, Your Lordship, would reach so many people that may have had concern about the EVM. It is very helpful, Your Lordship, and I hope and trust that equally the court will be assisted in understanding the EVM machines. Apart from that, Your Lordship, other issues they remain as addressed in our 3 affidavits, Your Lordship, and we therefore ask Your Lordship that the application be dismissed in respect of each and every relief. There are reliefs that I did not address, even including election that have already passed, Your Lordship.
Yes, it appears from your papers. Those submissions appear from your papers.
Yes, Your Lordship.
You say, for instance, that those candidates who have already been elected should also have been cited.
Exactly, Your Lord. We stated that in our papers. I therefore submit that and pray that the application be dismissed with cost, and such cost, Your Lordship, should include cost of 2 legal practitioners, and to be paid jointly and severally by the applicants, Your Lordship. As the court pleases, unless the court has any question.
What do you make of Mr. Maletsky's submission that you shouldn't be here because you weren't properly instructed?
The point he raised, Your Lordship, with greatest respect, was not capable of being understood. I tried, was not in great, with respect. You either take the point, at the point like that, Your Lordship, as you may know, is taken at the beginning, because then it means that the legal practitioner is non-suited to represent the party. You can't simply, in buying your time, refer to the point and then tell the court, I'm just raising it. That point is not open for Your Lordship to determine, because it was not, if there are other people that understood it, is not open for you for determination, because I was allowed, and we were allowed to argue the matter. He had the choice. We could stand up and say the court must determine it, Your Lordship. I therefore, Your Lordship, I do not intend to keep you waiting by
Well, as I said, take the time you need.
as the court pleases.
Mr. Maletsky, anything?
May it please the court, my lord. My lord, as far as the authority with which counsel for the respondents addressed this honorable court, I submit, my lord, with respect, that the time at which that point was raised is irrelevant, my lord. It is incumbent on the respondents' counsel of choice to produce evidence to that allows him to appear on behalf of the respondents. More so, my lord, in circumstances where statute or a specific section, as in this case the Proclamation of 1982, directs. There is no basis in law, my lord, that this court can simply ignore such provision that clearly directs the office of the government attorney to comply with the provisions of that proclamation by submitting a resolution duly taken by the Council of Ministers to support the respondents being represented by an attorney other than the government attorney.
Yes, but what if, in view of the limited time they had, that cannot be done? Does it then mean that the respondents must appear unrepresented?
No, my lord. The respondents would not have been prejudiced if they were represented by one or other of the government attorneys.
Yes.
So the time is not the issue here, my lord. The fact is that they did not comply with the provisions of that proclamation. And that's a serious issue. My lord, with regard to the assertion that political activity does not include legislative participation of the citizens. My lord, the Constitution clearly, or interpreting the Constitution, to limit legislative powers to be exercised and to be the exclusive preserve of members of parliament is unheard of.
Well, they represent the populace, don't they?
My Lord, if in an established democracy, a practice set by parliament dictates that members of the public should be consulted, there is a legitimate expectation in the hearts and minds of the members of public to be consulted when parliament deals with the amendment of the supreme law. Members of the public, my Lord, it is a notorious fact that they took to the streets to demonstrate their frustrations for not being consulted in respect of the amendment of the Constitution. My Lord, the Constitution is a social contract, and the citizens must be fully consulted when it is to be amended. My Lord, the question which this court needs to take cognizance of is Section 209 and the Government Notice 208 of 2014, which resulted as a result of the latter section, do they promote the principles of the Namibian Constitution? That is the question, my Lord, that should be answered. We are living in a constitutional democracy, my Lord. There is no way that a provision of an act of parliament can escape the question of whether it is in line with the Constitution. In fact, every provision of statute must promote the spirit, purport, and object of the Namibian Constitution. My Lord, that it has not been
As a general proposition, that is correct. But where does it take you in the context of this particular case?
The fact remains, my Lord, that the manner in which it was used does not, in these circumstances, promote the underlying spirit of the Namibian Constitution. You cannot, my Lord, on the 11th hour, 29 days before the election is to be held, by way of a government notice, suspend provisions contained in the Electoral Act of Namibia, which were meant to safeguard transparency and to lead to a credible election. 29 days, my Lord, before the envisaged election. That is not democracy. In fact, there is a clandestine manner of using sections of the Act to cheat the Namibian nation of a free and fair election. The nation was under the impression that until the 17th of October, my Lord, that is 29 days before the envisaged National Assembly and presidential elections, that sections 97...
Because
Sorry,
cheating, those are not in the papers. This is a reply, Your Lordship, and he must reply on points of law. He is making sweeping allegations of cheating, which do not find place in their papers anyway. And in the reply, Your Lordship, he's abusing an opportunity to reply, Your Lordship, and I need to protect my client. As the court.
Mr. Maletsky,
With respect, my Lord.
it is advisable that you should confine your
Yes, my Lord, with respect. These
reply
issues,
to issues raised by Mr. Namanje.
Yes, my
But
Lord.
carry on.
With respect, my Lord, the fact remains that the government notice number 208, which the applicants deal with in their founding papers, was gazetted on the 17th of October.
You've made that point.
Yes, my Lord. With regard to which branch, it was mentioned by the Council for Respondents that a branch of government is not represented here, my Lord. An issue around non-joinder. With respect, my Lord, the government of the Republic of Namibia and all the respondents were properly cited and are before this honorable court. There is no prejudice, my lord, that any of the respondents could claim for non-joinder in this application. My lord, the fact that government is generally...
What about the other presidential candidates?
My lord, the other presidential candidates are not independent of the political parties.
Doesn't matter.
They are not independent of the political parties. In fact,
They don't stand for the presidency as a member of a political party. They stand as for an entirely different purpose, which is that of the presidency.
my lord, with the greatest of respect, all of the candidates, the presidential candidates, stand as members of political parties.
That may be so.
And the fact, my lord, that they stand as members of political parties, and the political parties were cited in this application, ipso facto joins them to these proceedings. There's simply no logical ground, my lord, where the deputy president of a specific political party, who is also the presidential candidate of that party, can claim ignorance of this application.
Yes.
Yes. My lord, with regard to the applicant's application being based on secondary facts, in the founding affidavit, the applicants raised concerns that the electronic voting machines were never before used in Namibia. That's a fact. It is also a fact, my lord, that non-disclosure of the software programs operating these electronic voting machines were not disclosed to the applicants. That's a primary fact. That, my lord, there is no hardware and software security that exists in respect of these electronic voting machines. That is a primary fact.
But there's evidence before me that there is.
It is stated in our founding papers, my lord.
Yes, but it's denied.
May I refer your lordship to, in fact, it is stated in the letter reproduced and incorporated in my founding affidavit, my lord.
What I'm saying to you is that those allegations, even if you make them, are denied on the papers.
That denial is insufficient, my lord. And it's not based. And there's nothing to support that denial. To simply deny an allegation. My lord, that is not, the case of the applicants is sufficiently
Mr.
made out in the founding
Maletsky,
papers.
you've appeared here on a number of occasions, and you will know what the rule is in motion proceedings, where there are disputes of fact, that the court will consider those admissions made by the respondents together with the facts set out by the respondents themselves, unless those facts are so improbable that they can be rejected out of hand.
That is indeed so, my lord.
Yes.
The applicants made out a case
Yes.
that warrants the intervention of this court.
Yeah.
And the applicants pray, my lord, that you entertain the very serious concerns raised by the applicants and
Yes.
grant the application.
Of course I will.
Yes, thank you, my lord.
Is there anything else that any of the other applicants wish to add?
No.
Nothing? I see Mr. Beerkes has left us in the meantime.
My lord, with respect, I was informed that Mr. Beekers is having a medical issue.
I saw he was wearing a walking stick. The gentleman from the Namibian Economic Freedom Fighters, is there anything you would like to add, sir? Nothing? Very well. Normally I would have preferred to take time to write a judgment, but in view of the urgency of the matter, I've decided that I'll deliver a judgment, even if it's an extempore judgment, tomorrow morning at 10 o'clock.
May it please.
Also rise.
Expensive pen is here.
May it please the court, my lord, I confirm my appearance.
Thank you, Mr. Maletsky.
On behalf of Mr. Yewat Bekus, my lord, I confirm that he's, due to medical reasons, he's unable to attend.
I understand.
May it please the court.
As the court pleases your lordship, myself and Mr. Nekwaya, for the respondents we represented yesterday, we continue representing them on instructions of government act on your lordship. As the court pleases.
I have in the limited time available to me prepared a judgment in this matter which I will proceed to hand down.
Presenting the 18th respondent.
Yes, I know. The 5 applicants launched proceedings by way of application not in the electoral court, but instead in the High Court, in which proceedings they seek the following relief. And I quote from the notice of motion. 1, that the applicant's non-compliance with the forms and service as contemplated in the rules of this court be condoned, and hearing this application for an interim relief as set out at paragraphs 2 and 3 below on an urgent basis as provided for in Rule 73(3) of the Rules of Court. 2, issuing a rule nisi calling upon the respondents to show cause, if any, on Friday the 20th of February 2015 why the following orders should not be made final. 2.1, setting aside the Namibian Constitution 3rd Amendment Act No. 8 of 2014 as unconstitutional for want of compliance with Articles 5, 17, 21 and 25 of the Namibian Constitution. 2.2, declaring Section 209(2) of the Electoral Act No. 5 of 2014, which authorizes the Minister of Local, Regional Government and Housing to suspend the application of certain sections of the Act unconstitutional with retrospective effect. 2.3, declaring Government Notice No. 208 of 2014 unconstitutional as it has no basis in law. 2.4, directing the first respondent to run a well-organized presidential and National Assembly election on or before the end of February 2015 or within such reasonable time period as this Honourable Court may direct. 2.5, declaring all the by-elections and elections of 2014 where voters had to use electronic voting machines in brackets EVMs, close brackets, null and void. 2.6, directing the first respondent to run a transparent and credible election on or before the end of February 2015 or within a reasonable time period as this court may direct. 2.7, directing the first respondent to stop using the electronic voting machines in brackets EVMs, close brackets, without the simultaneous utilization of a verifiable paper trail for every vote cast by a voter. And 3, ordering that paragraphs 2.1 to 2.6 above shall operate as an interim interdict with immediate effect. 4, ordering the first and second respondents to pay the costs of this application. 5, granting such further and alternative relief as it may please this Honourable Court. I pause to indicate that although the type of relief sought is for a temporary interdict and the issue of a rule nisi, that at least as far as the issues concerning the elections are concerned, the effect of whatever order I make will be of final effect. The elections is just around the corner. In fact, it's scheduled to take place this coming Friday, and the issue of a rule nisi will effectively and finally stop the holding of the elections. It is immediately apparent that the relief claimed in prayer 2.1 is a distinct and separate issue from the relief claimed in the remaining prayers. The relief claimed in paragraphs 2.2 to 2.3 is directed at the constitutionality of Section 209(2) of the Electoral Act Act 5 of 2014 and Government Notice 208 of 2014 issued in terms thereof. The relief claimed in prayers 2.4 and to 2.7 is directed at the way the upcoming elections and presidential elections will be conducted or has been conducted. On the other hand, the relief claimed in prayer 2.1 has nothing to do with the elections, but instead concerns itself with the Namibian Constitution 3rd Amendment Act number 8 of 2014. It is not apparent to me, nor does it appear from the applicant's papers, why these different issues which have nothing to do with each other were lumped together, so to speak, in these proceedings. The only explanation offered is contained in paragraph 6 of the affidavit of Mr. Maletsky, which reads as follows, and I quote, "This application marries challenges pertaining to the Constitution of Namibia and the Electoral Act 5 of 2014. Experience and convenience dictate that the jurisdiction of the Electoral Court must therefore yield to that of the High Court, which court derives its comprehensive jurisdiction to hear this application from Section 16 of the High Court Act, which provides the High Court shall have jurisdiction over all persons residing or in and in relation to all causes arising and all offences triable within Namibia and all other matters of which it may according to law take cognizance." Inasmuch as, close quotations, inasmuch as the passage quoted bears a reference to a marriage, I can only say that it is an unhappy marriage consummated by considerations of irrelevance and lack of persuasion. I shall nonetheless deal with these issues which I perceive to be within the jurisdiction of the High Court and not the Electoral Court. Before I proceed to do so, I am constrained to pass some remarks about the bringing of this application at the stage it was brought. The application, insofar as it concerns itself with issues around the upcoming elections, was launched at the eve of the elections and as one stated to be one of urgency. Consequently, I am asked to condone the non-compliance on the part of the applicants with the rules of the High Court. The applicants seek to make a case for urgency in paragraph 11 of the affidavit of Mr. Maletsky. From this, it appears that Mr. Maletsky was in possession of copies of the relevant statutes already on 20 October 2014. This application was launched at the shortest possible notice 1 month later on the 21st of November 2014. There is, in my view, no reason why the application could not have been brought at an earlier date without putting the respondents and the court to the inconvenience it did. The rules of the High Court are designed to ensure that litigants are afforded sufficient time to properly prepare and present their cases, and for the court to conduct its work in an orderly manner. The power to condone non-compliance with the rules of the court is a discretionary power. In the instant case, I have decided after due consideration and with a fair measure of reluctance to condone the non-compliance with the rules, insofar as they concern the relief aimed at the election. My reasons for doing so are twofold. Firstly, the respondents who appear to oppose the application were able in the limited time at their disposal to prepare comprehensive answering papers, and they indicated that they wished for the matter to proceed in any event. Secondly, the elections are due to be held in a few days' time, and I consider that to be in the national interest, that the issues raised be settled and decided upon prior to the election being held. I must add the remark, however, that the fact that condemnation was granted in this matter must be seen as a limited exception and not the setting of a general precedent. No case for urgency has been made out for the relief claimed in Prayer 2.1, and I will as a result not condone the non-compliance with the rules as far as that relief is concerned. The application for relief in Prayer 2.1 is accordingly struck from the roll. I turn to deal with the relief claimed in Prayers 2.2 and 2.3, which deals with the challenge on the constitutional validity of Section 2092 of the Electoral Act and Government Notice 208 of 2014. As a first leg to their argument, the applicants contend that Section 2092 of the Act empowers, in that it I will repeat that. As a first leg of the argument, the applicants contend that Section 2092 of the Act which empowers the 16th respondent to decide when portions of the Act shall be applicable as unconstitutional. They go on to state that in itself that is not permitted by the Constitution inasmuch as it conflates the functions of the legislature with those of the executive. I do not agree. To the contrary, I find the reasoning of the court in the case of Pharmaceutical Manufacturers Association of South Africa and another in re ex parte President of the Republic of South Africa and others, (1999) in brackets 4 SA 788, compelling and persuasive. The relevant passage in the judgment to which I refer reads as follows at page 796. J, and I quote, "It is by no means unusual in this country and in other states that recognize the separation of powers for the legislature to delegate to the appropriate functionary in the executive branch the power to determine the date upon which its enactments should take effect. Often, as in the present case, administrative preparations are required to be made as a prerequisite to bringing the legislation into effect, and it is best left to the executive branch of government to determine when the appropriate time has arrived. In the constitutional structure of this country, it is the President as the head of the executive branch of government who is the appropriate person to whom to delegate that power. However, the power that he exercises in that regard is not one delegated to him by Parliament and not one that is conferred upon him by the Constitution. In such cases, such delegation was down through Section 55 of Act 132 of 1988, close quotation. I need to add only that it is indeed in Namibia often the case that the power to determine when legislation should come into operation is vested in the administrative branch of the executive dealing with the legislation. I've indicated that I agree with the reasoning expressed by the court in the pharmaceutical manufacturers case, and I find that the law in Namibia is exactly the same. It follows that the submissions of the applicants on this score are devoid of merit and must fail as a consequence. As the second leg of the arguments, the applicants contend that the electronic voting machines which will be used in the upcoming elections are not equipped to provide voters with a paper trail or record of the fact that his or her vote had been recorded. That fact is not in dispute. Based on that, the applicants contend that as a consequence, the constitutional right of citizens to take part in the elections and cast their vote is impaired and diminished. I accept that the right to vote has two components. The first is the right to cast the vote on the day of the elections. The second is that the vote so cast is recorded and counted by the election officials. The question whether the electronic voting machines without a proper paper trail, so to speak, meet these requirements is a question of fact which I must determine solely on the facts placed before me in the papers. The facts placed before me by the applicants are speculative and, in addition, sweeping in their nature. There are broad allegations of election fraud and election rigging without any factual basis to support that. On the other hand, as part of their papers, the respondents filed a comprehensive affidavit by Mr. Srinivasa Rao. Mr. Rao is an expert in the field of particularly the electronic voting machines used in Namibia at present. The evidence of Mr. Rao is in direct contrast to the allegations made by the applicants and dispels their fears and contentions. The approach of this court in resolving issues of fact in motion proceedings is well settled and clear. The approach is that in the final determination of the factual disputes, the court will have regard to those facts admitted by the respondents and the other evidence of the respondents, provided that the evidence is not so devoid of merit that it can be rejected out of hand. Based on that approach to the issue, I am satisfied that on the facts placed before me in this case, the use of the electronic voting machines will not have a result that the constitutional right to vote, in the sense that I've mentioned it, is lost or impaired. It remains for me to consider the relief claimed in paragraphs in prayers 2.4 to 2.7. These have nothing to do with the constitutional issues and are directed at the way the election will be conducted. In my view, these issues are issues within the jurisdiction of the Electoral Court and not the High Court. As a consequence, and sitting as a judge of the High Court in the present case, those issues fall outside my jurisdiction and cannot be entertained by me. I must also add that I am of the view that several persons or parties who have a substantial interest in this matter have not been cited by the applicants in their papers. However, in view of the conclusions I have come to, I do not deem it necessary to dwell on those issues at any length. In the result, the orders I made are the following. The application is, insofar as it relates to prayer 2.1, is struck from the roll. The application, insofar as it relates to the remaining prayers, is dismissed. The applicants are ordered jointly and severally to pay the costs of the respondents, which costs will include the costs of 2 legal practitioners. Court will rise.
Well, I expected the ruling. Because in Namibia, we know that the lady called Madam Justice has been subjected to many miscarriages since independence. We don't have an independent judiciary. So this casts a serious reflection on the integrity of the justice delivery system in this country. With respect to the ruling that was made, I put it to you that we expected this judgment, not because it's based on facts and legal principles, but because it's another miscarriage of justice that we are used to. And on that basis, we are going to approach the Supreme Court without further delay. Take note that this is the beginning of litigation. It's not the end. And the victory that the Electoral Commission of Namibia and those seeking to defeat the principles of democracy with these electoral voting machines is short-lived. We are going to dance to the dictates of democracy in the Supreme Court of this country. And this is no hollow talk.
Is there time, though, sir, for the Supreme Court to express itself on the matter, considering that the elections are taking place on Friday?
If we respect the rule of law, the moment we file the notice to appeal, the operation of law dictates that the election has to automatically be suspended.
Why did you go to electoral court? Why did you have to come to our court?
Because the relief that we seek is an amalgamation of constitutional matters as well as electoral matters. The High Court, and I respectfully differ with the judge, but he's functus officio at this point in time, has more comprehensive jurisdiction than the Electoral Court. So there was no way that we could approach the Electoral Court to entertain issues around the election as well as constitutional matters. We had to approach a court with a more comprehensive jurisdiction. In this case, the High Court.
The allegations of voter fraud, EVMs used, they are also without basis according to the statute.
Well, clearly, we are confident that the Supreme Court will give a judgment in stark contrast to the judgment of the Honorable Mr. Justice Miller. The case of the applicants is well-founded. It's not based on speculation. Look, it's not speculation that the paper trail is not there. It's not speculation that this software running these electronic voting machines has not been disclosed to all the relevant stakeholders in this matter. That's not speculation. It's a matter of fact. And as the judge indicated, these facts were never disputed by the Electoral Commission of Namibia.
So the fact that urgency was struck from the court, if you are taking it on appeal, will that not be clear?
Well, you see, oddly, urgency was conceded to by the respondents in an open court yesterday. Urgency was not an issue. So I must record my surprise at the ruling. When urgency was conceded to by the respondents, it was a done deal. For the judge to come and to entertain a different judgment that is in stark contrast to what the respondents conceded to. I told you, justice is a woman known for many miscarriages. So without discrediting the judge, whom I have the greatest of respect for, I am confident that once we take this issue to the Supreme Court of Namibia, we will have the miscarriage of justice set aside.
So can you give us Afrikaans? Just
Afrikaans.
very quickly. Is u teleurgesteld met die regter se uitspraak?
Ek is nie teleurgesteld met die regter se uitspraak nie. Ek het dit verwag. Wat my wel ongelukkig maak is dat ons weer eens bewys is dat die regstelsel in hierdie land nie die onafhanklikheid weerspieël wat dit in terme van die grondwet mee geklee is.
Wat is stappe verder?
Namibia is die land waar albei my ouers gebore is. Hier in Namibia speel 'n dobbeldiens. Ons gaan hierdie saak vat tot die hoogste hof in die nodig.
Your reaction about the judgment today?
I'm not surprised with the outcome. What I want to say, especially, I'm disappointed by the move taken by the official opposition to bring this application at this late hour so that they can put or keep the nation to ransom. This is most unfortunate. You recall, it was the opposition who were complaining about the past system of ballot papers. They wanted something more efficient. We went out of our way as government to meet their requirements, to meet the international requirements. That was the basis how the electronic voting machines were introduced. You recall they had an issue with tendered ballot. They had an issue with the paper ballots. They had an issue with the voters register. We attended to all those in the new law. They were complaining the old law was too complicated, which we agreed. The High Court agreed. The Supreme Court agreed. We attended to those issues. Now today they turn around again at the last minute before the elections to hold this nation to ransom. And this should not be allowed. Because as you know, contrary to what they are alleging, Namibia is one of those countries on the African continent which has good governance, democracy. In fact, we are in the league of our own, as you may recall, and this assessment is not done by us, it's done by the international community. We are in the league of top 10, sometimes even top 5 on the African continent. We are determined to make sure that our citizens are given their democratic right to vote.
What is the message to the Namibians out there who were eagerly waiting for the verdict?
To say definitely they must remain calm. They must follow what has been done now. Political parties have spent money to campaign. There's no way this process can be disrupted. We have received also international observers who are here to monitor the process. We have nothing to fear because ours is a government that is founded on the rule of law and democracy. Transparency is our watchword, and the elections must go ahead as planned.
Those 1 million people must go and vote now, Dr. Kawana.
Well, that one really, as we have always said, all Namibians with voters' cards who qualify to vote in terms of Article 17 of the supreme law of our land, the Constitution. Come Friday, they must be ready to take their voters' card, to stand in queues, to vote for the parties of their choice, so that the leaders of tomorrow must lead this country with confidence. They must know that they were democratically elected. The parties have sold their manifestos to this nation, and the party that is going to win, it will mean now there will be a contract between that winning party and this nation, because the nation would have accepted the election manifesto of that winning party.
Thank you, Doctor. Thank you very much.
Minister.
No, well, you see, really, the appeal, it's their democratic. Look, Namibia is a democracy, as I said. We cannot prevent them to appeal, but as far as we are concerned, the elections will just go ahead.
Minister Namolo, your reaction to the judgment. You were one of the respondents directly.
Yeah, as my Attorney General said, we were not surprised. We knew we were doing the right thing from the beginning, and to challenge the electoral law and the use of the EVMs. They were all consulted, agreed, and now we don't know why they should do all of a sudden turn around and question to what they have already agreed. Also, you get surprised. They say we speak on behalf of our people. Which people? If they are there, they have no followers than some of the political parties, and they claim to have the followers. I think this is a deliberate move to disrupt the democratic exercise of all our people. On the EVMs, it is we who have explained it to them, the absence of the paper trail, and we explained why. Even in India, this paper trail is not available to all the states of India. And now they want to use it as if they are the ones who know it. It is us who know it. And we know when it comes into operation, we will use it. So we just don't understand why. They, at the first, when they were by-elections, the opposition parties, they were the ones who praised the use of EVMs. And all of a sudden, it's a U-turn. You see that people are just trying to find reasons. If they lose, then they say the elections were rigged. So this is my understanding, that they are only finding some reasons before elections have started.
Thank you for your time, sir. Thank you.
We must get it.
So we have to get out of
I don't speak African.
Yeah.
I'm sorry.
Okay, well, I think let me explain something on the EVMs.
Thomas, just quickly.
The registrar one.
Yes, we are having, I will give the Honorable Minister a chance.
Yeah.
We are having other proceedings in this court.
Yeah, just quickly, 2 minutes. Where is it? You are ready? Yeah, you see, on the EVMs, even the allegation that they brought before this court is not convincing. Just as General Namolo said, we even paid for their expenses to go to India. We were so kind to pay for them so that they satisfy themselves. Now they come here, they make wild allegations against EVMs. You see, to me, it's like a person who has never been inside an aeroplane. It's not an aircraft engineer who will tell the pilot, this plane is not fit to fly. It's exactly like that. They don't have a clue about EVMs. What they brought before court has nothing to do with the technicalities. They never included the expert opinion expert analysis of the EVMs, but it's just from their own head. This is totally scandalous, as far as I'm concerned.
Thank you, sir. Outside.
Yeah, outside.
Go this way.
The ECN is to us to inform the nation that the ECN is prepared for this election, and we thank God for the judgment because it dispels any uncertainty over whether this election will be held on the 28th. So certainty has been brought that the election will proceed as planned, and we are informing all the electorate to go out in full force to come and vote. All those who are registered voters should ensure that they come out because there's no uncertainty any longer. The election shall go ahead as planned on the 28th of November. And we welcome the judgment specifically because of the aspect of the unconstitutionality of the use of the EVM without the paper trail has been cleared. Clearly, what has come out from the judgment is that it is practice and law in Namibia for the executive arm to be allowed to decide when a law shall enter into force, when a statute shall enter into force. So this has been cleared. Therefore, what has been gazetted by the Minister of Regional Local Government and Housing with regard to the use of verifiable paper audit trail, that it is not required at this point in time, and that it will only enter into effect when he puts a notice in the government gazette. That is now clear from this judgment, that it is not illegal for us to use the EVM without the paper trail. And therefore, we can proceed to use the EVM without any problem for this election. And we encourage all our electorate to come out, vote, and know that it is not illegal for the Electoral Commission to use this EVM. And we are very happy that this aspect has been cleared now by the court.
Now, the court case, did it somehow distract your operations at the ECN?
Well, it did not distract our operations because our operations people have been focusing on the operations as planned, and they have been at their duty stations, and they continue to be at their duty stations, and therefore operations have been continuing while other colleagues have been dealing with the aspect of the court case.
The judgment has been very clear, as you said, on the issue of the EVMs. Now it's putting finally the matter to rest because a lot has been said about the use of the EVMs. And from the High Court, now it's a clear indication, or not even indication, it's a clear statement that EVMs are allowed.
Definitely that is the case, because it has come out clearly from the court that the facts that were put by the applicant were speculative with regard to vote rigging and fraud. It was speculative, and that it was not based on any substantive fact. And it was clear that the expert evidence given by the Electoral Commission on the use of the EVM was regarded as positive and accepted by the court. And that, I think, is very important for our nation to know, that this expert evidence has been accepted, and it is clear that there is no problem with the Electoral Commission using the EVM. So this aspect has been dispelled, that the EVM is not reliable.
Just your final message to those that are still doubting the EVMs.
My final message to those who are doubting the EVM is that they should go and test it for themselves. The proof is in the pudding. Let them go out, go and vote, test, and we see how the results will come out. Because clearly we have already shown success in all the 5 by-elections that we have held. There has been no contestation of the results, and therefore we really urge the electorate to stand by the results that have already been received for all the by-elections. There were no problems with the functionality of the EVMs. None of the parties contested the functionality of those EVMs. So therefore, we really urge our voters to dispel any doubts and fears which this court judgment has done. And they should go out with full faith and go and vote in peace.
Another issue, Advocate, it's the issue that came up yesterday of polling officials who were complaining of not being paid. What does the ECN has to say about that? Because they seem to be not willing to be part of the election.
Yes, I think it's very unfortunate because in actual fact, these polling officials are being well paid. For a period of 12 days, somebody who's unemployed will be getting 3,000 approximately for 3 days, for 12 days work. That is the salary of some people for a month's wage, for a month's work. And therefore, what we are saying is ECN, those people who are prepared to work for ECN and who have the nation's interests at heart, who are patriotic to this nation, they should continue. And those who at this hour are still not of the view that the money is sufficient, there are many people who are willing to work for ECN. So we are working with those people who are willing to work. People have come voluntarily. Nobody has been forced to apply for a job at ECN. And those who are not satisfied, they are free to leave. Basically, those who have signed contracts already, which the majority have, they shall proceed to work with the ECN. And I think they should understand that what we are paying is a huge amount. If we calculate the whole amount that we're paying for almost 13,000 officials, it's millions, over 30 million. So I think really the Namibian nation, people should start to understand and appreciate the work that they receive. There are a lot of unemployed people.
No, but what is the current situation now in case some of them perhaps refuse to go work? Only one day to go.
We have already dealt with that issue. Those who are not willing to work have already been identified, and we have already made plans to replace them. And those people are being trained now as we speak. So therefore, we will also use others who have been trained already in the critical areas. So they are not indispensable. Those people who are not willing to work, they are not indispensable. We have enough people who are on our database, who are trained, and we are prepared for the election with those who are willing to work. Thank you.
Thank you so much. We're from the SAPC.
Are we done?